Good morning, everyone. I have already taken some time to start the morning, which it is still morning here, with prayer and some offerings. And I'd like to start this space here with some drumming to really be able to put our hearts together, right? Physiologically, sort of get in line with each other. All right. I'm going to hand the microphone virtually over to Princess to open up our intentions today.
Good morning, everyone. I just want to take some time for us to acknowledge that the conversation we're about to have has and have affected real people, real communities, real families. And as we move forward with our discussions about ICWA, just remembering that real human lives, real children are on the forefront of this. Just setting that intention. Thank you, everybody, for being here.
Thank you, Princess. And I'm Jack Trope. I'm moderating this session. I'm a senior director at Casey Family Programs in the Indian Child Welfare Program, and I'm pleased to moderate this panel made up of Elisa Mercado, Rolissa Teehee, and Princess Koyansi. They will each tell you a little bit more about themselves before they start talking. But first, let me just lay the groundwork. And so I think for those of you, welcome to all of you today. And if you were at part one, welcome to part two of this discussion about the Indian Child Welfare Act and the Brad Keene Supreme Court decision. Thankfully, this will be a much more positive discussion in general, although not without some concerns that we'll continue to raise, but much more positive than I think we feared. And those of you who sat in on that first conversation, I think know what could have happened and what people feared might happen. So what actually happened is that the Supreme Court did not find the Indian Child Welfare Act unconstitutional. And so there were three main theories that had been presented to arguing that ICWA is unconstitutional. The first one was that it was beyond congressional authority to enact the ICWA, and the court came out very firmly and said, no, this is well within Congress's authority to enact legislation on behalf of Indian tribes and Indian people. The second argument had to do with states' rights and whether or not by commandeering or forcing state agencies to do certain things, it violated the state's rights protected by the 10th Amendment, which reserves to the states all rights that aren't specifically given to the federal government. And the court found that no, it did not violate states' rights. It found that the requirements in ICWA around things like active efforts apply to anybody who attempts to have a child placed in out-of-home setting. So that could include an adoption agency. It could include guardianship, private guardianship, a lot of other circumstances other than when the state gets involved. And so it was not uniquely a state burden, and so did not violate their rights. The third issue, equal protection, was the argument about whether or not ICWA was a race-based statute as opposed to being based on the political status of of Indian children and families. And that part of the decision was not, there was not a ruling on the substance. What the court found is that none of the parties in the case had standing to raise the issue. And what standing means is that whether you have a right to be before the courts only hear real cases and real controversies. And the court said that none of the plaintiffs had a harm that they could address in this case. So they had no right to be before the court on this issue. And that the state of Texas could not sue on behalf of its citizens, that it didn't have that power, and that it hadn't been directly harmed itself. Now, so the substance of the placement preference issue was not addressed. However, interestingly enough, in the standing analysis, the court focused almost entirely, or really entirely, on the placement preference provisions. It did not really get into at all some of the larger arguments about where they were arguing that the whole statute was unconstitutional. So that may be an indication that the remaining equal protection issue is focused on placement preferences and not the broader challenges that we feared that might actually impact tribal sovereignty much more broadly. Although we'll see. Obviously, there's nothing to prevent anybody from making any argument before any court that they would like. Where we expect the new, these issues will be raised going forward would be in state courts, as opposed to through the federal court system. So that's kind of an overview. And we still have certainly the challenge of implementing ICWA the way it's intended, which has happened here and there, but certainly not happened in many places. And so that doesn't change. And so with that introduction, I'd like to sort of bring our panelists into this to provide their insights. And so what I'd ask you to do is to, well, first introduce yourselves a little bit, and then talk about what stood out for you in the Supreme Court decision. So we don't have any particular order, so whoever would like to start off, please do so.
I can go ahead and start, Jack, if that's okay.
Sure.
So my name is Elisa Mercado, and for those of you who joined on part one, I am an attorney who is working currently at the Loyola University Chicago Child Law Clinic, where I primarily practice in the areas of child protection and domestic relations. Prior to my position here at Loyola, I was at the University of New Mexico, where I was working in the Southwest Indian Law Clinic and in the Native American program of New Mexico Legal Aid, where I represented individuals in tribal and state courts. And that's really where my practice with the Indian Child Welfare Act and with Indian law in general was started. I have experience, like I said, in tribal courts, working with tribal court counsel and social workers on Indian law issues and Indian Child Welfare Act issues, representing children where the Indian Child Welfare Act applies, or where I'm arguing that it should apply. And I will say that my general reaction to the Brackeen decision, I'll say when it first came out, on a personal level, was just it was a very celebratory reaction. And so my first reaction was very personal, individual. It was very emotional, with fellow attorneys and friends who do this type of work, who are individually impacted by this decision. And essentially we just, and I'm far away from New Mexico, where I'm from, where I primarily practiced in Indian law. And my first reaction was to reach out and talk to people who we do this type of work and celebrate, because it is really an accomplishment. There are some issues, as Jack mentioned, with equal protection, and it's not a complete victory, but to be really happy that it's better than what was anticipated. So that was my first personal reaction. As a professional, I will say my reaction was that the decision, which was authored by Justice Barrett, I noted that it was very technical in its language. And as Jack had mentioned, that it was, when it came to standing, that it was very technical. And rather than get into the merits of equal protection, which we all feared, it was essentially reserved for another fight, for a future fight that potentially could be brought through the courts. So as a professional, my reaction was, while a victory, and while I'm happy that it turned out better than I had anticipated, maybe I'm the only negative Nancy who anticipated something that could have been far worse, was that, well, we're not done here. And there's a lot of work to be done, and a lot of, both with non-practitioners of Indian law and practitioners of Indian law alike, and interdisciplinary work to be done. And that was my initial reaction.
Thanks, Elisa. Melissa or Princess?
I can go second, if that's okay with you, Melissa. Hi, I'm Princess Kuyansi. I'm a member of the Yavapai Apache Nation. I am the granddaughter of Frank Kuyansi and Pauline Jackson, and the daughter of Clark and Gloria Kuyansi. And I'm also the mother of two children, two tribal member children. In my life, I've had the opportunity to work on both sides of the ICWA conversation, not both sides as in against it, but on the side of benefiting for it and then also advocating for it. When the decision initially came out, I think that my first feeling, similar to Lisa's, was like, wow, we got this. And I think also was like, I couldn't believe that we had it, just considering how this SCOTUS has acted historically. So there was a feeling of that, but then also similarly, like, what's now? Like, we are still at the table. What are we doing with it? What does it look like? How do we prepare our communities for this, to have to be in the room and to be strong advocates in it? Because I think that it's a very, not being a legal expert, it's a very legal thing that's happening, and these conversations are happening, are making decisions in the communities, right? And I'm like, so now we know that we're at the table, but what do we do with that? What does that look like? How do we make the best out of what came out of this? I also acknowledge that like Elisa said, that left room for another fight, which kind of has always been the thing, right? But right here, right now, what do we do and how do we prepare for that? I think was one of my biggest reactions after, almost like shock that it was upheld. So that's that.
Melissa?
Osio, Wadulisi, Dihi, Dawado. I'm a citizen of the Cherokee Nation, working through Utah State University, occupying the traditional lands of the Northwestern Band of the Shoshone Nation, and lands that have been shared by many other Shoshone and Bannock tribes, among others. I'm an assistant professor in psychology, director of the Tohi Lab, and we're really focused on holistic Indigenous wellness. I have a law degree from the University of Arizona and a certificate in Indigenous Peoples Law and Policy. And really, like, I try to use these Western educations to really attend to these issues that law and policy are impacting our Indigenous peoples, and thinking about things related to identity formation, mental and behavioral health, as I mentioned, well-being. And as we're thinking about sort of Indian Child Welfare Act, all of these things come into play. And so for me, the background in law just helps me understand what is going on in these situations, and to be able to have conversations on this level. Because initially I sort of first realized I didn't know how to do many of these things in working with domestic violence or violence against Indigenous women, and realizing there are jurisdictional issues and who is Native and who isn't, and what type of land you're on, Indian land or not. And it became very complicated in my undergrad sort of research and interests to even begin to approach how you could start to address these things. And with that comes the Indian Child Welfare Act as well. So I first heard it being further west and somebody who wakes up later than the average person. I woke up to a lot of text messages about the release of the findings. And for me, I was super apprehensive. So the first thing I did is like go to the actual opinion. And then I was like, well, this is 133 pages. Like, I'm not going to be able to get through all of this yet. And so I was very apprehensive of celebrating much until I had a chance to really like dig into all of it. Cause my thought is like, there's gotta be a catch somewhere, right? There's something, because historically for quite some time, the Supreme Court has, every time a tribal sovereignty case has come before them, has started to whittle away at tribal sovereignty. And so for me, I was like still like waiting for the, okay, but what's the other part? Well, maybe other people who are reporting on this haven't read the whole thing yet. You know, I'm just not sure. So I was apprehensive for the celebration. So that took a few days for me to get to like feeling really good about this. But I think having read through it and having a lot of discussions, there are many things we still need to do. And as Elisa and Princess mentioned, like it's not over. It's not like, oh, we can just, this is a said thing, it's a done deal, we can rest. But continually trying to think about what our next approaches are, what do we need to be aware of, and that kind of thing.
So before I ask another question, I will just mention also that if you want to read a very powerfully pro-tribal, pro-Indian children and family decision, skip over the majority opinion, which was, you know, again, much better than we thought it would be, right? But look at Justice Gorsuch's opinion that was joined in part by Justice Jackson and Sotomayor, where he goes through the whole history of the treatment of Indian children and families and the importance of tribal sovereignty, and it's an amazing opinion. So if you are going to read something, don't just stop with the majority opinion. Certainly read his opinion as well. Well, the next question I'd like to ask, and you all started to sort of talk about this, but what's the implication of this for future cases, and what are some of the future implications of the decision as you see it?
Well, Jack, before I answer what I think that maybe the future implications are, I just wanted to quickly acknowledge what Princess was mentioning, that this is it can be very legal and technical in the opinion, at least very weighty, and that what Princess had said, and she can correct me if I'm wrong, is that a lot of these decisions for tribal communities are made by non-tribal members, by the Supreme Court. All of these legal decisions are oftentimes very separated from tribal members and tribal communities. And it just in reaction to what Princess is saying, I think that at least for me, that's oftentimes why I have an emotional reaction when I first hear about anything ICWA related, whether it's an article with a very conservative slant on the Indian Child Welfare Act. I tend to react emotionally first, because a lot of the press, at least after Baby Girl back in 2013, it has since become a little bit better with the Brackeen decision, was oftentimes removed from these tribal communities and from those who experience the day-to-day life on a reservation. And oftentimes, when we do these presentations, we don't have, at least, we're maybe just missing that perspective. But I really appreciate that we have Princess who can speak on that. And I think that, at least when it comes to the future implications, I think on that same line, if we have more tribal communities and tribal members, as well as practitioners of Indian law who are involved with the state court proceedings that we have that are going on for involuntary removals, whether it's a private guardianship or if it's an adoption proceeding, then we have this push, at least on SCOTUS's level, that the Indian Child Welfare Act is constitutional. And we have that momentum to continue that involvement of all walks of life in the Indian Child Welfare Act, where maybe that had died out a little bit in previous years.
Oh, Elisa, you were right. Oh, Jack, you're muted.
Just quickly before Princess starts, I meant to say, if you have any questions, please put it in the Q&A, and we will deal with that after we have finished our own discussion. We will certainly be happy to address any questions you might have. I'm sorry, Princess, go ahead.
I was just going to say, Lisa, I don't think I put that together as well as you did, but absolutely, there's this bridge between this decision and what that actually looks like in our communities, and oftentimes being in this line of work, I've had ICWA representatives in some of these proceedings or in some of these discussions and some of these conversations. And unfortunately, what is understood legally and what that person's capacity is are not bridging together, or even their understanding of what it is or how to even advocate legally in those moments. And so when we talk about like how this impacts the communities, I think we feel really excited and we're ready to go, but how do we prepare people to be ready to go in those conversations? Because it is a very legal and big thing. And it does feel sometimes disconnected from some of the people who are in the actual day-to-day conversations of it.
Thanks, Princess. Melissa?
I think part of the findings in this case and the opinions that were released, the opinions were pretty strong. And so it definitely, thinking about future implications, I think it shifts potential cases that are moving their way up to go before the Supreme Court again. I think people who are groups that have sort of been attacking ICWA for a variety of reasons, that many of which have nothing to do with Native children, probably pause at some of those and thinking about bringing those cases forward at this point. So I think there is implication there. I think one of the things that has happened in multiple states since the opinion was released is states putting in place ICWA laws and procedures. So Maine put theirs in since the finding, and then I think Nevada, and I'm not sure about others just right off my memory, but really going in and thinking about this, because there is sort of this like minimum level that is required by ICWA, but states are much more, they're much more in touch with the needs of their own citizens, including tribal citizens. And so they can actually put things in that are going to work better for certain places, right? Like what works in Washington, D.C. is not the same thing that works in very rural Washington state. And so, and thinking about sort of that, right, how much the rurality versus urbanicity and things, right? And how many like resources that are available and that type of thing. Those things look different in all of these places. And so that is, to me, a very heartening thing that is happening at this time.
Well, thanks. Those are, I think what you're hearing in part is that there's still so much work to be done to make ICWA work down where it matters in the individual cases. And also, though, I think Melissa's comment where hopefully some of the more extreme arguments are not something we have to deal with to get to where we need to be, which is these individual cases moving forward the way they're supposed to. All right, I'm going to move on to the next question. And so, of course, we know we have a lot of people attending today who are not lawyers. I think probably very few who are. And so the question is, how can the attendees from the various disciplines that we have here today respond to the decision, and are there things they can do in support of Indian children and families?
I'll go first on this one. So I think one of the ways that we can support Native American families in this is, first off, with whatever profession we're in, whatever line of work we're in, preparing with education. And one of the things that I know, like I mentioned before, I'm a member of the Yavapai Apache Nation, and I've had discussions with their tribal council about, as families go through tribal court, having available education pieces on what does this mean? What does ICWA mean to you and your family? What does that look like? What are the things that this affords you? So I think just getting the education out there, one, for any family that's involved with the family court system. And then for two, preparing our families as social workers and mental health providers and even substance abuse counselors, all of these different things that make a whole family, coming together and really having intention set for building healthy families. I think that, while I'm really grateful, and in no way am I saying not grateful that ICWA was there, there's this huge responsibility for us to have healthy families for these children to be kept with. We're fighting to keep them at home. So home needs to be healthy. And what does that look like? And so I think we've all anyone who's worked with BIA or worked with tribes and in that sector, we see the grant monies that come in, maybe possibly, or maybe tribes are setting things aside, but really in each one of us having this intention of how do we build this community up to be healthy, to have children returned here, to return to healthy homes where they're going to thrive, where all of these things that we're protecting are actual things that they're getting. So that's the way that I think that the interdisciplinary attendees can show up, is knowing that maybe there needs to be extra attention put on building healthy families. Maybe there needs to be extra attention put on educating on what ICWA is, what it affords, what it looks like, and making sure that as our tribe hires or puts people in positions of being ICWA advocates, that they're prepared for that they have the education behind it, they have the understanding behind it. And I'm not saying, just lawyers, but if anybody who's in that position has a full, real, well-rounded understanding of what ICWA is, because I think that's kind of, this is all for naught if we're in the room and we don't know what to say. It's great to have a place in the room, but what are we doing with it? So that's my opinion on how I think that they can support Indian families, is through education and support.
And to go off a little bit of what Princess said, I agree. Education is one of the most important aspects we can have going forward, and not just education for tribal advocates, but also education for judges on the application of ICWA and what to do when you have a child who has the Indian Child Welfare Act applies in a case. You know, when it comes to child protection, I think that at least since ICWA started really going through the courts back in 2013 with Baby Girl v. Adoptive Couple, where it was the huge case with very sad circumstances, and it was one of the first challenges that were on, at least on the large stage across the nation, highly publicized Indian Child Welfare Act. One of the ways that it was spinned, at least in favor of the adoptive couple in the news, was using the very sad circumstances, which unfortunately are very typical in child protection cases, in favor of, well, look at this child who is caught in the middle of this federal legislation, who is being prevented from having a permanent and stable home with this lovely couple who want to make this their forever home. And because I think that your average American, your average professional is very unfamiliar with the child protection process and how it can be ugly for everyone involved, even in the best of circumstances, and how oftentimes there's not really a great decision to be made, but maybe a slightly better decision to be made. And there are a lot of sad facts involved, unfortunately, that it was used in a very effective way. And it has, like I mentioned earlier with Brackeen, the tables have turned a little bit, and the press around Brackeen has been more positive for tribes, tribal sovereignty, and keeping families together in a culturally appropriate setting. And maybe that's due to societal changes. But if your average American or your average professional becomes more educated about what child protection proceedings look like and how they can last years, then it won't be that cheap tactic that can be used to turn people against the Indian Child Welfare Act and against tribes. So that education on all levels, judges, tribal members, advocates like Princess had mentioned, your therapists, social workers, if everybody is educated on these pieces of the system and we're all knowledgeable on why we're doing what we're doing, then I think that we'll find more favor with the public and more support amongst everyone for these children who are caught in very ugly circumstances.
I think to add more to this too, thinking about the different disciplines that come into contact with child welfare in some way. I think having knowledge about this is really important. Nicole Johnson and Key Straits did a survey, and I think they must have put the results out maybe last month, within the state of New Mexico, with those who work within child welfare in some way. So thinking about legal services, thinking about therapy services, but adoption services, advocates, right? All of these things. And they surveyed these folks. And so to start, New Mexico has some of the most comprehensive state laws and procedures around the Indian Child Welfare Act. And so it is something that is very well established there. And they surveyed people, and I think that almost a quarter of the people didn't know what ICWA was. And they're working in this environment. as they went, over 80% of people said that they had never had any formal training or educating or anything around ICWA. And I can't remember, I'm trying to remember the percent here if I scroll quickly. I think, 81% said that their knowledge of ICWA was low to maybe moderate, and only 6% said they had a good amount of knowledge on ICWA. And I mean, that is shocking and concerning in many ways. I think also looking at as somebody who is coming to this from psychology, like making sure to look at the different sort of narratives that are being put out there, and why, right? So thinking back to the baby girl case and coverage, right? There was a lot of coverage around this, white family who was being discriminated against because they were white, and the bond that they had, and this really like emotional process, and focusing on those things and not at all on why the Indian Child Welfare Act exists, on what we know about the health and well-being of people who are totally separated from their culture, their communities, those types of things. So I think making sure to sort of think about this from multiple perspectives is important. If you have a particular case that comes before you in the work that you're doing, yeah, that's what I have right now. I'll have more thoughts and I'll circle back around in a bit, I'm sure.
Okay, well, actually, I'm sorry, Princess, go ahead.
Oh, I kind of wanted to add to what Melissa and Elisa were saying about, additionally to that, like we need technical understanding of it. We need the understanding of what it means legally. We need understanding of how it's implemented. And as judges and the people who are making these decisions are learning this, I think there also needs to be an understanding for what it means to be a Native American child in our Native American communities. I grew up on a reservation in a home that had 6 biological children, 4 adopted children, where we slept on the floors together. And my dad didn't make very much money because he chose to make sure that he was home when we got home from school. And we packed bologna sandwiches and rode horses to the Verde River and all of these things. And I remember at one point, we had a non-native social worker come into our home because my mom and dad had adopted these additional children who were also tribal members, but had came via the state. And she came in and she was like, all of the children need to be removed. Their biological children and the adoptive children, they don't have their own beds. They, the dad doesn't make very much money. There was all of these things like that. My family wasn't prepared to take care of these children because we weren't living by the non-native standard, I guess, or by the native way of living. But if you ask me and you ask, my siblings and whatever, we had a wonderful life. I didn't even know we were what non-natives consider poor or whatever until we were in our 20s, because my parents made sure I had all of the things that I needed. And so I think sometimes that some of that's missed when they're having these comparative arguments of, well, this is a 2-person home and dad's a doctor and mom's a whatever, and they're non-native and look at all these wonderful things. They can buy them the first power wheel, or, they have their isolated rooms that are cold and that they sit by themselves in, as to where for us, that feels like that would be devastating. And I think that sometimes not understanding the population is just as detrimental as not understanding the technicalities of it or understanding the legal side of it. So I think when we talk about implementation and what it means to us, I think that that's another big piece that needs to And I know we hear it like it's a buzzword, like cultural competency. And, we probably all have at some point or another sat through a class where they were like, oh, and the Native Americans don't look each other in the eye. And it's all these like kind of like generic things about us, but really having a true understanding for who we're representing, why people might have certain arguments they have, and not taking away when the standard, I don't want to say standard of living, but the way of living is just different. It's going to be different. We're different, and it's okay.
Right. And one of, I believe it was Judge Catherine Begay, who presides over the New Mexico State ICWA Court, or did a couple of years ago when I was there. She did an interview, and one of the important points that she made was that oftentimes in state courts, when you don't have judges or practitioners who are familiar with reservations or with Indian communities, that you get this tendency of judges wanting to put the child in the home that has the best economic resources, that they have the best financial resources, and essentially are seeing that the kids are trading up in a family. And oftentimes those are white families, and those aren't Native American families. And that is the ugly tendency of judges, even if they're unintentionally doing that they are applying their bias. And it's oftentimes financial reasons are used as kind of a cover for that bias. I remember I had a case where one judge cited that their house was warmed by a wood-burning stove, and there was not gas in the home. So what? That's very common in a lot of rural areas. But that was used as a reason to remove children from a home where they were otherwise loved. So to have that knowledge and to, actively fight against that tendency, and especially know that when, people are using financial reasons as, cover to have those biases present in cases, to really actively fight against that is very important.
So it's been a fascinating conversation. I think a lot of great information and perspective, I think, for folks. And it a couple of things triggered a couple of things for me. I mean, one is this whole idea of communication, right? That all of you can be part of. And Elisa mentioned the baby girl case, and there were one of the big failures of communication there was that people weren't even aware of the fact that during that case, for about 2 years, the child was returned to her dad, who was a very competent, capable Cherokee father, and that never even. People didn't even know that. And when the court decision came down, tragically, they took his daughter away from him and sent him back after 2 years. So, terrible situation. But this time around, I think the messaging did get through to the court. You even saw the justice who wrote the opinion in Baby Girl, who showed no sympathy whatsoever in Baby Girl. In his dissent, he was one of the 2 dissenters, but he acknowledged the interest of tribes in keeping people connected with community and culture, and even acknowledged that in some cases, that the best interest of the child would be connected to that, which was a pretty amazing concession on his part, given his Baby Girl decision. So if even the one of the 2 dissenting judges is seeing fit to put that in his opinion, I think it shows that a lot of the messaging did get through to the court. But that doesn't mean the messaging has gotten through to the whole world and the child welfare system. As Melissa indicated, the lack of knowledge is shocking out there. And so I think all of you hopefully have a better understanding, sort of talking about the importance of ICWA. Some of you may know at Casey, we call ICWA the gold standard. And one of the reasons we do is because it prioritizes keeping children with their parents or their guardians or custodians, whatever it could be done safely, that's the first priority, that removing kids is traumatic in and of itself. We often focus on the trauma of abuse and neglect. We don't often focus on the trauma of removal, which can be devastating. And that it also emphasizes keeping children connected with their communities and cultures. And so I think, to the extent you have the opportunity to share some of this information with others who may not be as familiar, I think that's a role that you all can play. And I know some of you serve as CASAs or maybe guardian ad litems or some involved in the system. And so I think sort of understanding that, making sure you fully understand the tribal perspective when you go in, but also knowing that sometimes the tribe won't be there because the tribe doesn't have the resources to be there. They have the interest, but they just don't have the capacity. And I will tell you, some judges have this attitude that if the tribe isn't there, well, we don't even have to worry about ICWA, which is totally not true. They still have to follow it, and it's in the best interest of everybody involved that they do follow it. So if you're in there as a CASA or a guardian ad litem, maybe an expert witness, being able to make sure that this does get enforced in that case, even if the tribe isn't there, I think is a really important thing for you all to think about. So I just want to add a few thoughts based on the great conversation that the three panelists were having. Any other thoughts on this before we move to the questions and answers?
Just wanted to add a little comment. Oh, sorry, Melissa, go ahead. I didn't see you off or on. Sorry. I just wanted to add a little comment on there when you said in terms of like, sometimes judges have this feeling of like, if they're not here, then it is what it is. I've also seen that when there is a representative there that kind of has the pre-rehearsed answers and gives the right answer in the moment, but then further argument happens around it and they don't interject, that either the tribe is in agreement with it, or sometimes when the representative doesn't have the right answer, or maybe doesn't say things quickly enough, or whatever that looks like, doesn't understand the conversation as readily. I've also seen judges look at it like the representative was flippant and just didn't care. And so I think that is a really powerful tool, is if we're in the room and we know that there's a response, or we know that there's something there that's missing, is feeling empowered to speak up and to say that, because oftentimes these nations do not have the resource, nor do they have unfortunately, the right person in the position. And that's not any fault of their own. It's just, it is what it is. So I think anytime that we're able to step up and support it in all of our different professions as we understand it, I think is very powerful. So thanks for bringing that up, Jack. I just wanted to add on that a little.
Yeah, and I was going to add too, like consulting with the tribes in your area, in your state, is always important to do. So even as states are looking to make their own policies or procedures, but if you are, I don't know, running a social work program in a state, reach out to the tribe and see if they have any resources you can use, if they have anybody that would want to come and share their experiences with you, share about the procedures with you. Also, paying people for their time is a good thing to do. So rather than reaching out to people and saying, could you come out and educate us? I think, compensating for that and figuring out ways to do that is a really great start, and something that I think just doesn't happen very often.
Right. And it seems like such basic advice, but it really isn't always fault to communicate with the tribe. I'll say that just even a few days ago, I had a state's attorney where I'm serving as guardian ad litem for a kid, ask me if the child is a member of the tribe. And my response was, I don't know, but I can ask the tribe. And it wasn't even a thought for that attorney to ask the tribe if this person qualifies to be a member in their tribal community. And instead to ask the guardian litem, which I'm happy to do that, but it hadn't occurred to them that yes, the tribe can be, even if they haven't actively intervened, they can be a great resource for everybody involved. and can give you some insight into this child's community. And also the BIA website, they list the designated agents for each tribe. So you have a phone number and an email. I think they have an email listed there too, to get in contact with whoever is supposed to be the point person. Or you could just Google the tribe plus I don't know, governor's office, and then you would come up with a general number, and you can ask that governor's office, who do I talk to about Indian Child Welfare Act cases? And they would be happy to point you in the right direction 9 times out of 10. I have not had any issues with somebody not wanting to give me the appropriate contact for their tribe.
And I would also mention that, I think Melissa mentioned state ICWAs and other advocacy things that happen, and tribes have been instrumental in pushing those state ICWAs, but they have had supporters along the way. They've had non-Indian organizations, they've had child welfare experts, they've had a lot of different people who have supported some of those efforts. So also understanding, in the advocacy side, there can be support for these sorts of things that tribes are advocating for. Anything else before I see there's 4 questions. Anything else before we take a look? Okay, well, let's see. So the first question is whether the child will be returned in the Brackeen case, I presume, to the Navajo grandmother. Well, I guess I can answer that one. There was actually, I don't think the grandmother was involved in that case. It was a Navajo family. And when this court challenge happened about 5 years ago, they sort of backed off and said they didn't want to move forward because of the challenge. And so the adoption did go through. And I don't think that's going to be reopened. It was one of the reasons that the court found that they had no standing, because they said there was no harm to be dealt with. They already, in their case, their adoption had already gone through. So we will go on to the next question. Increasing number of now adult transracial adoptees and former foster youth sharing their stories and counteracting the savior tropes of adoption. What are recommended resources, narratives for folks in therapeutic roles? Would you like to tackle that one?
So I think as somebody who works in therapy and works with people in that way, I have seen a lot of sort of identity work that people need to do when they're adopted by somebody of another race. But that to say, people don't come to therapy when the things are working great. So I don't tend to see that side as much in this way. But this is one thing I was going to say with the prior cases, there has been a lot of messaging and there's these stereotypes of reservations or tribes as these like desolate places that the people are poor, and so the lifestyle is inadequate, and there is like all of the data shows that there is actually like no difference amongst groups. White people have just as many issues with neglect and abuse and things of children in similar ways. So there's not this sort of narrative and this stereotype of what I'm seeing, as the savior, or the white savior, like, I'm doing them a favor. I would say, like, I wouldn't give up my connection with my family and my tribe for money growing up. My childhood, right? We had wish sandwiches, Princess. So it was bread and Miracle Whip, and it was a wish sandwich because you wish you had something to put in it, was the joke my dad would say. But that's not a thing that, like, I mean, here I am. That was not problematic in that way because families come together. And so you just have lots of people providing different things. And so I think in thinking through some of those things, there are a lot of issues related to being disconnected from your culture, no matter what your culture is, thinking about this from a psychological perspective. And so, yeah, I think challenging some of those messages about, coming in and what a great thing you're doing to help. It's something we need to do with each of these stories, and recognizing that for some people it works out really well as well. But that is likely not the majority.
I kind of wanted to add on that one with the savior tropes and these different things that come into place. I mean, for any Native American child growing up, that tends to be kind of a narrative that's given to us, right? Like we quote unquote lost the war when it was really disease, but that's another story for another time. But at any rate, we've come to this space where like we're never going to be non-natives. We know that we've all these years, and the forced assimilation and colonization and whatever. And I don't think there's this idea that we want to be, but in us never being that non-native way, it's kind of put in minds of some young people, or maybe even people who have been adopted, who are put into non-native families, that they're never going to make the standard of human. Like we're subhuman, but they're the perfect human is like the white male, whatever that look, or non-native, male, whatever that looks like. And so I think that when these people are growing up and are coming to their own spaces, it's a really unique space that they have to find, because we're not non-native, but we also aren't allowed to be native anymore. That's a thing that's been taken from us. The things that are passed down, from, when we used to go look over there, we used to go and swim in that hole, or we used to go hunt here, that's all stripped from us, right? And we're on these little pieces of property. So what do we do with this? And how do we get our children through this? And so working with kids for a long time, and even adults, is, one of the things I tell them is, you don't put your head down because you think we lost. You raise your head because we've been through this and we're here. There was huge efforts put in to take everything from us. So let's collect what we have. Let's take pride in it and let's learn it. So I don't know if that helps or not, but connecting those people with their communities where they can find things to be proud of, where they can feel what it feels like to participate in our traditional ceremonies, to eat the food, to be in the community, where when you look around, because it's the only place on earth that Native Americans have, like we don't get to go to another country and fly there and get off a plane and everyone looks like us. Our reservations are the only place we have. So go home and find your empowerment there. Go home and find your ancestry there. Go home and find your roots, find your pride there. Because trying to make it a non-native, you're not going to be a non-native. And again, like I said, we're not going to be out there, unfortunately, the way that we should be. So what do we have left, and how do we capitalize on that? So handling those savior tropes, I think, is kind of that way, is you don't need saving. You've made it, you're here, you've survived. Go get it, go find it, go feel it. It's good. So encouraging them to reconnect with their tribes and with their identities and the things that are still really beautiful that are left of their people. I think it's my response to that.
Thank you. Very, very eloquent and powerful. If it's okay with you, Elisa, I'm going to move on to the next question, unless you had something to add on this. No? Okay, because I do want to try to get through them. I think we have done another less than 10 minutes now. So the third question is, there seems to be a greater appreciation for an emphasis on kinship care by state and federal governments. Do you think this will help address some of the challenges, such as cultural competency, that have been discussed?
I'll say that from my perspective, and I know that I have a differing opinion than some others who practice in this area, would be no. And the reason why I'd say no, because oftentimes as ugly and as prolonged as child protection or child welfare cases can take, there are certain protections that are afforded to children, to families, to parents that are available in children's courts and juvenile court systems that aren't available in domestic relations, civil courts, domestic matters, where you typically see custody cases and where you see divorce cases. In children's court, you see more attorneys, you have more eyes on children. You have, even if it's a case is taking years, sometimes that's not necessarily a bad thing. I mean, obviously it's not a great circumstance if it's taking years, but you might need those eyes on children. And for kinship care cases, and obviously this is going to differ state by state depending on what laws you have, they oftentimes are shorter in their duration, and they don't always guarantee that attorneys, not all parties are afforded attorneys as of right, as they would be in a juvenile court case or in a children's court case. So you will see parties who are pro se, who are arguing very complicated issues and are not going to be able to advocate for themselves as effectively as if they had legal counsel. You also don't have the resources that are, that are required to be provided to families, as you see in children's courts and juvenile courts. You don't. It's a shorter process that is not, that there's not as much money put into those types of cases as there would be for a child welfare case. So in my opinion, I do not think that it's a good replacement for a case that would go through those other court systems, especially when it comes to the Indian Child Welfare Act. You have very complicated issues, and sometimes the duration, how they're longer, it will afford the tribe an opportunity, or at least somebody to get in touch with the tribe, because maybe they haven't been notified early on in the proceedings, to intervene in that proceeding before a child is placed with somebody. So sometimes that can be beneficial for the child in the long run, because removals, as you all know, I'm sure, can be very traumatic for children. And if at all possible, the parents get the resources and that child can return home, then that's a success. And it might just take longer than it would, than a guardianship proceeding, a private guardianship proceeding would provide.
Yeah, and in addition, the research on kinship care. So if we want to think about empirical research in this way rather than people's experiences, which are also very meaningful, but the research shows kinship care is beneficial to all children, not just Native children. But Native children are removed from their homes as the first step at a way, way higher rate than any other racial or ethnic group within the US, and are less likely to be placed in kinship care than, say, white children or other children outside of ICWA. And it's one of the reasons that ICWA is still in place, because we do not have equity in these settings yet. These biases are coming in, all of these things. So I agree, like, kinship care is helpful for everyone. And it should be one of our first resorts for all children. It's just not happening that way in practice.
If I may just add a couple of thoughts, and then Princess, if you do, please also join in. But, I think what Elisa is identifying is that she was focused, I think, on the private guardianship issue as opposed to sort of kinship care in the child welfare system. But in the private guardianships area, I mean, it's sort of a good and bad type thing. The good thing is that you're keeping children hopefully with family, which I think, as Melissa said, is a good thing. But those families tend to be supported far less, and they tend to have far less resources available to them. And so that's a real problem, that you know, you should be able to bypass the child welfare system, but still be just as supported as you would have been if you went through the child welfare system. And yet the way we have things set up, if you go through the child welfare system, you get a lot more supports, as Salisa was saying. If you go through the private guardianship system, you may just be on your own. And so while that can be a good thing, because, you know, if grandma's stepping forward, it's better than a stranger, but somehow that inequity there, that's an inequity too, that we push kids into the child welfare system who could have been kept within family, in more cases probably if there were more supports, or who are kept with family and that family struggles way more than they need to because they're not supported. So I'll just kind of add those thoughts. And Princess, anything else you want to say about this?
No, I think they both have that covered. I think that some of the reasons why, though, that Native American families are removed more, or Native American children are removed for, is because some of that lack of cultural competency that I was talking about earlier, is that there's just this idea that we're not able to take care of our children, or maybe that homes are overpopulated because majority of us live in multi-generational homes, or, you know, these different things that they view as reasons why we're not capable. But as we move through this in our positions, is understanding that we are capable, and we're happy there.
Great. Well, I have one last question. I think we have time to answer this, to probably time out just about right. And the last question is, can you go a bit more into how the merits of the Equal Protection Clause have been saved for a future fight, like you mentioned briefly in the beginning? What implications does it have that we do not have a clear ruling on the Equal Protection Clause? I have a couple of thoughts, but first let me see if any of the panelists would like to tackle that one.
We'd love to hear what you think about that.
Okay. Well, I mean, obviously, you know, these arguments will continue to be made in state courts. And I think at some point may make their way back to the Supreme Court, although I'm not sure, other than Justice Kavanaugh, that the rest of nobody else joined his opinion. So I don't know if there's a huge appetite there to take another case down the road, but you never know. But I think this will play out in state courts, and I think most of the litigation is going to be around the placement preferences, particularly the one that in the oral argument there was a lot of focus on, was the third placement preference in adoption, which is other Indian families. So the first two preferences are family and Indian child's tribe. And then the third one was other Indian families. And that seemed to be a big target. And so I think you'll still see adoption attorneys trying to make arguments about the adoption preferences, especially, you know, that third preference. Could there be broader equal protection arguments still being brought by the anti-sovereignty folks and all that? I mean, they can still bring them. I mean, you know, and undoubtedly somebody will somewhere. But I do think it was interesting that the court didn't, when they were talking about equal protection, didn't even talk about that, because if they had, they probably would have found Texas had standing. Because they would have said Texas is injured by and they went out of their way to say, well, there's nothing, the placement preferences themselves don't injure Texas, and so they don't have standing. So that kind of suggests that these broader arguments hopefully won't have a lot of traction, but I think we can anticipate litigation around the placement preferences, probably for the most part the adoption preferences, because I think it's the adoption attorney community that's been the most hostile, you know, in this process. So, but anybody else want to add to that? Please do. Okay, so I think we are at 4 minutes before the end. I don't know whether the organizers have any last words for folks that they wanted to offer or any of the panelists have any last words I'd like to offer.
I just want to say thank you to everybody who's interested in this conversation and everybody who is on the front lines and in the courtrooms and everywhere else. Like, thank you for taking the time to think about this and being interested in it, because it matters. It matters to our community, it matters to our children.
And go ahead, Lisa.
Just to just thank you. Just as Princess said, thank you for joining, and thank you for listening to all of us. If I can go ahead and just read maybe just a little bit from Gorsuch's his concurring. So one of the things that, and in case you don't have time or the inclination to read the entire opinion, he says in his concurring that in adopting the Indian Child Welfare Act, Congress exercised that lawful authority to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. All of that is in keeping with the Constitution's original design. I think that's, if you don't want to read the majority opinion, Gorsuch's is great. And it gives a good historical perspective as well as a very academic perspective on why the Indian Child Welfare Act was brought into being.
Thank you. That's, I think, a nice way to end this. And thank you to the Alliance for taking the initiative to put this together. Melissa, are you going to?
Sure, I will just sort of drum as people are leaving. So thank you, Wado. Thank you.